Morning. Morning. I don't repeat my greeting because I'm looking for like a chorus of responses. I do it because the greeting is how I signal to you that it's time to transition into class time. And when I repeat myself, it's because there's people who didn't get the message. So hopefully now that I've said that, you will recognize what's going on. So I want to start today actually by talking for a quick second about how I'm managing this classroom, because I've had some students come and chat with me essentially about cold calling. And there's sort of two things that are coming out of these conversations. One is that cold calling is nerve-wracking. And the other is that when I cold call on folks who don't have the right answer, sometimes folks get confused and they second guess themselves, right? You may have gotten the answer right when you were prepping for class, but someone says something else and you start going, wait, what's going on? And so I want to talk a little bit. I want to talk about why I'm doing what I'm doing. And then B, I want to very briefly pull back the curtain on me so that you can kind of see where, so that maybe you'll be a little more comfortable. The first thing that I want to talk about is why I'm doing what I'm doing. I think that it's very easy for students and faculty to sort of talk past one another on issues of pedagogy and classroom management, right? Where it's easy for students to decide that professors don't care or haven't thought about the effects that our pedagogical choices have on you, when in fact we've thought about them a great deal, right? I want to be very frank with you guys. Like the traditional paper chase type cold calling where you read this sort of very mystifying extract of a judicial opinion, and then the professor walks in and asks questions that you have very little way to predict what they're going to ask. And to some extent, it feels like there's this expectation that you're supposed to read the professor's mind, right? Any of you feel that way? Maybe not in this class, right? I see some folks shaking their heads. Like maybe you don't feel that way in this class, but like you feel that way in that kind of situation, right? Maybe. I hated that feeling when I was a law student. Hated it, loathed it, despised it. But this isn't that kind of situation. You are not being asked to read my mind. You are not being asked to predict what I'm going to ask you. You are not being asked to like dive headfirst into 3,000 words of Court of Appeals nonsense and divine meaning from it. You are being told explicitly, these are the questions you are going to be asked, right? When I expand on that list, when I follow up, you know that it is because I am trying to get you to the answer to the question that you were given. And so I'm sort of the opinion that like, If you have prepared properly, if you have done what you have been asked to do to prepare for this class, cold calling should hold no terrors for you, right? Because you have an answer prepared that you think is right. Now, it may not be right, right? Which is the other issue that students have raised with me, is that like cold calls on someone, they give an answer and it's wrong, and it makes you wonder about your answer. And I am sympathetic to that as well. However, our purpose here is not only to bestow upon you substantive knowledge or procedural knowledge. We haven't talked about Erie yet, so that joke won't land for you guys. But substantive legal knowledge, right, is not the only purpose of your legal education. We are also engaged in skills development. And listening to an argument and being able to hold it in your mind and compare it with your own argument is an important skill for lawyers. Okay. Let me put it to you like this. Okay. If you are litigating a case and there is a contested issue of law in this case, how many opinions are there for what the right answer to that contested issue is? I'm not going to cold call anyone. How many opinions are there?
1, 0.
Expand on that, Mr. Roberts.
It's a contested issue, then it would be like it might have been decided in other jurisdictions, but it's not decided in yours. So you got to convey, like you got to tell the judge and convince the judge that, hey, like my position's correct.
Okay. You're using opinions in the sense of judicial opinions. I am asking you, how many different stances will there be in this case related to what the proper disposition of this contested issue of law is? I see fingers. At least 2, right? You may have a complex case where like where there's lots of parties and they all have different positions. How many of those positions are going to be right? 1, right. How many people who hold different positions are going to be convinced that they're right? The correct answer is N, where N is all of them. Okay. And so when you are litigating contested issues, assuming you become litigators, or even in transactional work, there will be disputes over what things mean and sort of what you're willing to agree to, blah, blah, blah. But you will have to be able to listen to someone who takes a different stance than you, is utterly convinced that they are correct, and still have the confidence to press your own position. And so listening to your classmates be wrong is part of that skills development. Okay. Here's the last thing that I want to say about this. I really want to thank all of the students who came and talked to me about this, because, like I began this conversation with, I think that it is easy for students and faculty to talk past one another, right? It's easy for me to think, of course, they recognize that, like, I'm thinking about this and I'm being thoughtful about this, and the choices that I make have reasons behind them. And it is very easy for you guys to go, this guy's just an arbitrary bastard. Okay. You know, I don't understand why this is happening. And so clearly there can't be any reason, right? And so I really appreciate the students that came to me and talked through this with me so that I had the opportunity to say, okay, we need to talk about this. We need to explain this so that you're all understanding why I'm doing what I'm doing. And I think that one thing that sometimes happens for students, maybe not for you guys, but for other student populations that I've dealt with, is that this space here between us feels insurmountable. In that, you know, you guys look at me and I'm here behind this podium and I'm sort of, you know, endowed with the authority of this institution, and, you know, I'm using branded slides, and, you know, so it looks like I'm very professional and I always have my act together, and the truth is, y'all, I'm goofy as hell. And I'm about to show you what I mean. So, you know, so this is just, you know, I put my pants on one leg at a time, just like the rest of you. Okay. And you should not be afraid to come and talk to me about things that are on your mind. And the last thing that I'll say about it is, like, if despite all of this, you're still nervous, like you're worried, you think, you know, oh, I'm gonna come in and criticize him and he's gonna retaliate against me, which I'm not going to do, but like, it's a fear that students have. Go and talk to Dean Lowry. Okay. Part of her job is to pass along student issues to faculty. Now, what I will tell you is, if you go and talk to her and she goes and she sort of thinks to herself, this is a garbage issue, she will very quietly put it in the circular file and I'll never hear about it. But if it's something that needs to be brought to my attention, she will do so, and she will do so while protecting your anonymity. She will say, a student has come to me with this. Okay. All right. So now that we're done, you know, having our group therapy session, let's start talking about removal. Okay. So, Ms. Caballero.
Yes, sir.
A sues B in state court on a federal court of action. A then decides that he no longer wants to be in state court. May A remove the civil action to federal court?
I put no, because only according to 1441A, only a defendant can.
Right. Exactly right. Okay. So keep in mind that state courts, courts of general jurisdiction, right? They can hear any case on any grounds for any reason. There are exceptions, but like, we're not discussing state civil procedure in this class. So you're absolutely right that state courts can hear cases based on federal law. Okay. This is what's called concurrent jurisdiction. Okay. Concurrent jurisdiction between the state courts and the federal courts. So if the federal courts can hear a case, unless there's a statute that grants exclusive jurisdiction to federal courts, for example, Voting Rights Act cases, state courts can hear those cases. Okay. So, Ms. Morgan, why do you think it is that 1441A only allows defendants to remove cases, right? So I'm asking you to speculate a little bit when I ask this. What policy choice do you think this reflects from Congress?
I would say that they're not allowing plaintiffs to remove it, because plaintiffs are the ones that are filing the action, and that their attorney should be doing the proper research in what court to bring it. That way it just can't be can't just be like easily removed.
Exactly right. I'm gonna rephrase it a little bit. Plaintiffs get their choice of forum because of the concurrent jurisdiction of state and federal courts. One second. And so plaintiffs have already exercised that choice by filing in state court. If they wanted to file in federal court, they would have. Where there is concurrent jurisdiction, right, where federal courts have jurisdiction, the removal statute reflects the policy choice that defendants should have the opportunity to choose a forum as well. Okay? So if defendants acquiesce to the state court forum, great. If they want to be in federal court, they should be. Mr. Simmons, you had your hand raised?
Just a quick question. Could have A just brought it in federal court originally? Anyway,
I'm sorry?
could have A like brought it in federal court originally?
Yeah, that's what concurrent jurisdiction means, right? So the plaintiff, where you have concurrent jurisdiction, the plaintiff gets to choose state court, federal court, okay? So here is, I'm gonna ask this question, and I'm throwing this out to all of you because this is a policy question. There's not really a right answer here. Is it right that like the defendant gets the last word here in terms of forum choice? Yeah, Mr. Booth.
Probably, I would say yes, because the only place that can move here is somewhere less biased.
What do you mean by less biased?
Federal court should inevitably be less biased than the state court, considering that they have employed these specific sets.
Yes, Ms. Gleason.
Kind of to add on to what Isaac said about it can't be the opposite. They couldn't choose to go from federal to state so much as because then they would get a more favorable court. Right?
Yes, Ms. Sadler, right?
I would say yeah, because like if the plaintiff brings it, then the defendant has the choice to either stay or change. And if they say to stay, then that's still a choice that they're going to make if they would have the last decision. But if they want to change it, then they still have that choice to change it. So I would say they would get that last choice.
Okay. I'm going to go off script for a second here. Anybody here heard of the Monty Hall problem? Mr. Booth, what is the Monty Hall problem?
Goats and cars. You gotta put 3 boxes, I'm guessing.
So
behind 2 of the doors are goats, and behind 1 door is a car. The game show host asked the participant to choose one.
So let's pause here. Mr. Hoover, choose one. All right. What happens next, Mr. Booth?
Game show host knows which door the car is behind.
Yep.
And wants to make it interesting to improve ratings. And so decides to close 1 door or however you will.
Reveals that there is a goat behind one of the doors. And then what?
So now it's a statistics problem where originally you had 33.
Well, what's the next thing for the game show?
Host asked if you want to switch.
Mr. Hoover, do you want to switch?
Mahomes asked.
All right. So here is the statistics. I'm not going to go down the rabbit hole of like explaining why this is the case. But the statistics say once you have been offered the opportunity to switch, always switch. Always switch. You are going to be more likely to find the car here than here given the information that you have? Why did we go down this bunny trail or this goat trail? Because to some extent, this is the game that the parties are playing in removal. Okay. Plaintiff has a choice of forum. Clearly, they are going to choose the forum that they think is more favorable to them. Okay. Defendant has to decide, do they want to acquiesce to the forum choice of the plaintiff, or do they want to switch? Okay. So essentially, you have been shown the goat, right, by the plaintiff choosing a forum, and you have to decide, stay or switch. Okay. Without any more information, always switch. So here is sort of the last question on this particular tangent, and then we will move on. What might be some additional information that defendants could use to decide whether they want to stick or switch? And then this is, I'm not going to call, this is open to all of you. Yeah, Ms. Caballero.
I think the #1 rule is always know your judge. So I
Okay.
think that they would look at who would be judging it and their record and decide which one they think they might have better chance.
Okay. I think that's right. I regret to inform you that the story we tell you about federal courts being less biased geographically, there's some evidence of that, but what there's a lot more evidence of is that federal courts are generally more defendant friendly, regardless of geography. So yeah, like if you walk into Kemper County, Mississippi, right? One of the judicial hellholes that was well known for dropping hundreds of millions of dollars in med-mal cases. Yeah, okay. Maybe you want to remove. What other information might you be interested in? Yes, Mr. Adams.
If the plaintiff is well known in the community that they're trying to sue in.
Sure, right? If the mayor of Topeka is filing a lawsuit, then maybe the Shawnee County courts are not where we want to be. Maybe we want to move this up to the District of Kansas. What else? Yeah.
Travel consideration.
Sure, right? If you file this in Colby and you can drag it into Wichita to a federal courthouse, that's a much easier trip, pretty much wherever you are, right? Maybe not if you're in Denver. Maybe Colby's preferable to Wichita in that case. So what else? Yeah, Mr. Fogg.
How sympathetic the defendant is.
I mean, I hope you'll know that because this is your client, but you know, sure, right? The defendant identity. What about the source of law? Are you going to be more likely to remove a case if the federal jurisdiction is based on 1331 or 1332? Mr. Strummer?
31.
Arguably, yeah, right? Because probably federal judges are better at understanding and applying federal law. So, At least we would hope so. So the decision to remove, for a lot of defendants, it's kind of automatic, right? They treat it very much like a Monty Hall problem. For other defendants, they will consider some of these things, right? And in terms of plaintiff choice of forum, I will tell you a story. This is a story from that a lawyer I used to work for told me. I don't know what I think about this heuristic. I have, it's testable, but I haven't tested it. He said, okay, I have a map in my office. He practiced in Arkansas. I have a map in my office of the 2004 by county presidential election results in Arkansas. And this was in like 2013 that I had this conversation with him. So not after, the Trump administration, in the middle of the Obama administration. He said, I choose 2004 because I think 2008 and 2012 were distorted by the racial dynamics of that presidential race. I think there's a lot of racist Arkansans who might be open to voting for a white Democrat who were not going to vote for Barack Obama. And so he says, I look at 2004 because that was like white dude. If John Kerry won the county that I would be filing in state court, I file in state court. If George Bush won it, I file in federal court. So I offer that to you as a potential heuristic for forum choice. Maybe it works, maybe it doesn't. Okay? All right.
Professor.
Yes.
Bloomberg Law, which everybody can get free access to, actually breaks down statistics based on judge, court, county, and what cases have been filed there and how often they side with the plaintiff or defendant.
So that's going to be useful information for you as well. And I'm going to quietly steal that. But here's what I will caution you on. And this is going to be the last thing that I have to say about this. Making these kinds of decisions based on whether prior cases were decided for the plaintiff or for the defendant is going to give you a distorted view of the patterns in that jurisdiction. Why?
Outlier.
I'm sorry?
Like the outlier, what if you have a case that wouldn't be statistically in line with that?
I mean,
Based on
a large enough sample, outliers are accounted for, right? That's how statistics works. So yes.
Because if you're just looking at who won, you're not looking at why.
We can, again, if the sample is large enough, all of that is accounted for.
I'm thinking of Moneyball. We're talking about statistics, and they couldn't get to the World Series just because they didn't have the bank account of the New York Yankees. They're still just on athletics at the end of the day.
I mean, it is part of that, right? Do all cases end in a decision for the plaintiff or for the defendant?
No, a lot of them settle.
Depending on who you ask, somewhere between 70 and 99% of the civil docket settles. And what if there is something that is systematically different between the cases that settle versus the cases that go to a decision? So this is what we call selection effects. It's a massive piece of my research agenda. And if you want to know how to deal with it, you have to go across campus and take a bunch of classes in the statistics department. I know you all came to law school because you were told there'd be no math. So that's why I came to law school. Couple of things that I want to emphasize related to the removal statute, right? Because all of this has been about like forum choice, okay, which is related to the question of whether you're going to remove a case or not. But you got to remember that removing a case does not grant jurisdiction over the case. There has to already be jurisdiction over the case. Okay. And so you really, before you start the removal process, you have to review the complaint to make sure there is a valid source of jurisdiction. Okay. Questions about all of this? All right. Mr. Van Diest. So I'm about to show you a map of the United States district courts for the state of Florida. There are 3 districts in Florida. There's a southern district, a middle district, and a northern district. And so my question to you is, can a defendant remove a case that was filed in the Circuit Court of Miami-Dade County, so Miami-Dade County, can they remove that to the United States District Court for the Northern District of Florida?
No, because under 1441A, it's being the same district and division. And
Right.
so it'd be in the Miami's in the southern district, not the northern.
Right, exactly right. Now, division in this context refers to the fact that most federal courts, most district courts have more than one courthouse. Okay. For example, in Kansas, right, we have courthouses in Topeka and Wichita and maybe somewhere else. Maybe in Kansas City. And so each of these divisions has specific counties that they draw into, right? That they are the appropriate venue for. If you file a case in the Circuit Court of Shawnee County, the defendant cannot remove it to the District of Kansas, Wichita Division. They have to remove it to Topeka. Okay. This matters, by the way. This matters because judges are assigned cases by division. So in some district courts, judges only get cases that are filed in the division where they sit. Okay. In some courts, judges are assigned proportions of cases from each division. So they might get mostly cases from the division where they sit, but they might also get some cases from other courthouses. Okay. Here is the sort of the dirty laundry part of that process. There are lots of divisions in district courts where there is one active judge. In particular, in the Eastern District of Texas, in the Waco Division, and in the Northern District of Texas, in the Wichita Falls Division, there's one active judge. And what has happened is that interest groups have begun forum shopping by filing in those particular divisions. So for example, the one active judge in Waco was really excited about patent litigation. And if any of you are patent people, more power to you and him. It's not how my brain works. But he actually would go to conferences and CLEs and whatnot, and he would advertise his court as a great place to litigate your patent cases. And at one point, 1 out of every 5 patent litigation cases was being filed in Waco, freaking Texas. The one active judge in Wichita Falls is so reliably a supporter of conservative policy preferences that the state of Texas only files lawsuits challenging federal policies under either the Obama or the Biden administrations in the Wichita Falls division. And the forum shopping became so blatant that the chief judge of the Northern District of Texas assigned herself 20% of the cases being filed in Wichita Falls on top of her full docket in Dallas, right? She was also getting a complete caseload in Dallas, so she overloaded herself specifically so that litigants would not be certain of being in front of Judge O'Connor that was making all of these rulings, setting aside liberal policy initiatives, right? So this forum choice that the statute forces on you really does matter because it can affect the outcome of the case. All right? Questions about this? We've gone a little afield today, so it's okay if you're like, wait, what the hell's going on? Okay, so questions? Bob?
If you wanted to make sure that, let's say with this Miami case in Florida, and you were certain that you probably wanted to have it moved, couldn't you, as a plaintiff's attorney, just file in one of those upper counties and then the
Sure, plaintiff could,
plaintiff,
but the defendant can't drag it across the state.
Okay.
Yeah, so in the removal process, you are stuck geographically wherever the case was initially filed. Okay. Other questions? So like basically the plaintiff gets to choose like in what area the case will be heard. Defendant gets to choose which level of the court system. Okay. So other questions? All right. Ms. Olive, is it true that any action pending in a state court over which the federal courts have original jurisdiction may be removed to the appropriate federal court?
No, not all. It may be removed. It may not be removed if any of the parties in interest properly join and severed as defendants as a citizen of the state in which such action is brought.
Well, in that case, is there original jurisdiction at all?
You mean for the state? Well,
For the federal court?
For the federal, no.
So then, I mean, you're right. You're right that the answer to the question is no.
Yeah.
But the reason that you've given doesn't speak to the facts as given in the question, right? So, Ms. Velasquez, Ms. Olive, like I said, is correct that not all actions pending in a state court over which the federal courts have original jurisdiction may be removed. My question to you is why? Think about what I said about the relationship between removal and jurisdiction. What is removal a grant of jurisdiction? Is removal a constitutional phenomenon? So that's, I mean, I think that's fair, right? Because this is a situation, right, where we're trying to expand upon the question you've been given. And so we are sort of in that environment, that kind of traditional, you know, guess what I'm thinking environment, right? So it's okay that you're like, I'm not quite sure what's going on here. So is removal something, is the opportunity to remove cases to federal court something that is inherent to the existence of federal courts? Why? Okay.
Because when you remove it's not for state to federal court.
I mean, that, yes, right. Removal is about going from state to federal court. My question is, does the act of creating a federal court necessitate that we grant defendants the right to remove cases? Is that a logical necessity? Can you not have federal courts without the right to remove? Is it impossible to have a federal court and not have the right to remove? That is correct, right? Absolutely. We could say we are going to create federal courts. We're going to give them original jurisdiction over cases involving federal law, where they're going to be experts, cases involving diversity, where we're concerned about forum fairness. Yeah. Every time I say we're concerned about forum fairness with diversity jurisdiction, I have to stop and go, yes, that's what you've been told. So, never mind that it's nonsense. It's what you've been told. So, but we could do that, right? We could provide supplemental jurisdiction over related state law claims, but we could also say the plaintiff has control over the choice of forum. We could say defendants do not get the right to remove. Removal is a policy choice by Congress to say we are going to create this back and forth between the parties, okay? And what Congress giveth, Congress may taketh away. Blessed be the name of the Congress. For example, if you go and look at 28 USC 1445A, this is a jurisdictional statute related to claims against railroads. Okay. The jurisdictional, or this is a removal statute related to claims against railroads. The jurisdictional statute is 45 USC 56. And the jurisdictional statute explicitly says that plaintiffs have a choice of forum for claims against railroads. They can file in state court or they can file in federal court. 1445A explicitly states that there is no right of removal for claims under this jurisdictional statute. So plaintiffs have the choice of forum. Now, if you look at 1445B, there are certain types of claims against railroads that can be removed with an amount in controversy requirement, right? But that's where the key piece of this is that Congress decides whether the right to remove exists. And we have examples that exist of them making decisions that go both ways. of granting the right to remove and of denying it. Okay? Yes. Ms.
Just
Bennett? Barnett, Ms. Barnett.
Just for like future reference, I think it's 1441A, not 1441B. B is the first.
I'm sorry?
In the rule book, I think it's 1441A that B. I think that will be well. B is removal based on diversity of citizenship.
You know what? I had the thought that I needed to bring a rule book with me, and then I didn't. So I believe you. I'm just.
No, I was just confused on this question.
Yeah.
Why.
Let's see.
Okay.
Action.
I understood it as talking about the home state bar for diversity removal. I thought that was the question.
Yeah.
Yeah. I think the question is right.
I do think the question is confusingly phrased. So I'll take a look at it and see if I can like piece together a better way to phrase it, because I know Professor Bider is working on a second edition of the book. And so like it's actually this is, you know, when there's little mistakes like this, it's actually helpful for you to bring them to our attention. Because then like, particularly on this book, because the author's down the hall, I can go, hey, like the rules have changed, right? It's not 14AC2 now, it's 14AD or 14A2D. You know, here, you know, this one's a little confusing because it's like, what statute are we dealing with? So yeah, I appreciate you bringing that to my attention. Okay. All righty. Questions? Yes, thank you.
I want to try to reframe what I think I understand. That from what we've discussed, it sounds like not all cases are going to be removable to federal court because in some situations that removal would destroy diversity and therefore the federal court would not have original jurisdiction.
No,
Okay.
no, it's much simpler, right? Congress decides whether defendants have the right to remove. In some cases, they say yes, you can. In other cases, they say yes, no, you cannot. And it's really just a matter of are you within the limits of a removal statute that grants you the right to remove versus are you falling in a category where a statute denies you that right? Okay, so even for example, right, under 1441B, there are time limits for removing otherwise removable cases. We'll talk about those a little bit more later in the chapter, but if you attempt to remove a case outside of those time limits, you're getting sent back. Okay. So now Mr. Heisen has raised a useful point, and so your reward is to get called on for the next question. Well, when you happen to ask a question that animates the next question, you should expect to see to get called on for the next one. So in a civil action where the citizenship of the parties is Kansas versus Alaska, Arizona, Missouri, and where we otherwise meet the requirements of diversity jurisdiction, my first question to you, Mr. Highstand, is there subject matter jurisdiction?
Yes, there is, based upon diversity jurisdiction.
Exactly right. And in which of these 4 state courts would the matter be removable?
You can remove it to the Kansas State Court because that is the district in which the state claim is filed.
Okay.
Well, I'm sorry. You said you can remove it to the
So-
federal court if it's filed in the Kansas State Court. I apologize.
That's right. Okay, why?
Again, it's because that is the district court within which that state court resides.
Well, okay, so I'm asking a slightly different question here than I think what you're answering. Assume that the plaintiff has filed in each of these state courts. So we're talking about 4 different universes.
Okay.
Okay, in which universe can the defendants remove?
The defendants can remove to the Kansas State Court, but not to Missouri, Alaska, or Arizona, because those are districts in which a defendant resides.
Right, exactly right. Okay, 1441 B2 limits the right of removal so that if the plaintiff chooses to file in a state court forum where a defendant resides, and if the case is strictly a 1332 case, right, we don't have a federal question, then the case is not removable. Ms. Holman, what policy choice do you think this reflects?
Like what's in the rule?
So Congress has expressed a policy choice by saying, if the case is removable on the basis of diversity jurisdiction, and if it was filed in a state court where one of the defendants resides, it is not removable. So what policy choice do you think is being expressed here? Think about it and let me see if I can maybe like make this pull back the curtain a little bit. What is the reason that diversity jurisdiction exists?
So that the defendant has a different they're not confused about that.
Would you ask again?
So we have a policy choice that is reflected in 1441 B2. That policy choice says we have created diversity jurisdiction for a purpose. That purpose is not being served if a case falls under 1441 B2. So, Ms. Holman, what was the purpose? Why does diversity jurisdiction exist?
So that there could be like so the defendant and the plaintiff don't have like the same date where they're filing?
Well, that's what diversity jurisdiction is, right? But what's the, let me put it this way. If the plaintiff is from Kansas and the defendant is from Missouri, do you think that the Kansas state courts have equal incentive to treat the parties fairly?
No.
Why not?
because they're gonna lean towards the person who's from.
Right, okay, this is the theory, okay? We will pause here to say it's nonsense, but this is the theory, right? And so diversity jurisdiction does what? That attempts to solve that problem, Ms. Holman.
I'm sorry, what are you asking?
So in an attempt to solve this problem that we've identified, right, that state courts do not treat out-of-state parties fairly, then how does diversity jurisdiction solve that problem? Or attempt to solve that problem?
By not allowing for the defendant to.
Diversity jurisdiction is a grant of jurisdiction, so it's not a not allow. Right? It's an allow. So Ms. Olive?
It gives the defendant the opportunity to remove to a court that's more impartial, but not move to their court, so that it defeats the whole purpose of allowing the defendant Kansas court, but going to Missouri court defeats the whole purpose of having that diversity rule.
Right. So this is it. This is exactly what we were where we were going, right? Because Olive has taken us all the way to the end. Which is fine, because we're out of time. So filing in Kansas state court, because none of the defendants live in Kansas, means that the purposes of diversity jurisdiction, being making sure that there's fairness for out-of-state defendants, is present. But if you file in one of the state courts where a defendant resides, then that purpose doesn't exist. And so in that case, the defendants cannot remove. That's what 1441B2 says. Okay, so we'll see you guys next week when we will pick it back up.
Professor, should we keep going 10?
Yep, 10 from wherever we leave off.
This is a question about.
No. Well. What category of jurisdiction? Yeah. Jurisdiction asks, it would work here, this type of. When we ask the question, is this case a diversity jurisdiction case? Are we asking a question that can be that? And this type of claim. So can the court hear this type of claim? A state law claim with diversity of citizenship is an amount of controversy exceeding 75%. These are characteristics of a claim, not characteristics of a party. Okay. And so we are asking about the type of claim. This is a diversity jurisdiction is subject matter jurisdiction. Right? So yes. Please go back and review chapter 11 of the book. That will help you understand this. Yep. Unfortunately, I was in the book.
I know it's set. But can you tell on the package?
But they use my both kinds.
Okay.
This one could slot the rest of the.
Yeah, it's wild.
These two different parts, so if any of the parts. So.
Yeah.
When, because this is the first listed defendant, they're not necessarily joined in the suit, right? So it was kind of, this could be what I'm thinking.
So
And if you get the free cup.
joiner's a little bit of a weird duck in that, like,
And now you.
every party is seen as joined.
Okay.
in so they're already done. I think the term of, yeah. We'll talk about this a little bit more Tuesday, but, what can sometimes happen is defendants don't always serve at the same time. So you get kind of a race, right, where if the first defendant gets served, so for example, right, if we filed in Missouri State Court, first defendant that got served with the Alaska defendant, they could remove as long as the Missouri defendant.
That makes sense.
Thank you. Yeah. Now, what was the name of that? Okay.
But anyway, he teaches here. Do you need like, okay, oh, like this summer, you mean? Yeah, no, that's awesome. Oh,